So, good morning, everyone. Let's start and welcome back to our weekly webinar series. Today's topic is an interesting one, and we are looking into the idea that how a resolution professional is as a public servant, and we will be discussing the decision of the Honorable High Court of Jharkhand in Sanjay Kumar Agarwal versus CBI. So, over to Anil sir to take it forward.
Thank you, Ankit. Thank you very much, all the participants. And it is a pleasure always that today is our 54th episode, Ankit. So it's like
55.
55th episode of AAA Weekly Webinar Series. And we try to bring out to you the new and latest subject. And this particular subject, the trigger came from a judgment of Jharkhand High Court that came in the last week. That was Sanjay Kumar Agarwal versus Central Bureau of Investigation, Anti-Corruption Bureau, and it is a case of Dhanbad. So it was the trigger, and where it was held by the Honorable Jharkhand High Court that an insolvency professional who is appointed by Committee of Creditors and confirmed by NCLT, it's a court-appointed officer and would be considered as public servant under the Prevention of Corruption Act. So then we thought of taking up this issue because I do recall that respected Shri Ravi Mittal, the Honorable Chairman of IBBI, in various meetings, he said, whenever we have spoken about the protection of insolvency professionals, he has said that if you want, I can even classify you as the public servant, and I can get that amendment made as public servant. You have to discuss amongst yourself whether you would like to be public servant or not. Although then after this judgment, I only would like to say, in the meantime, I will also start sharing my screen, because see, there are some sections and some kind of sharing that I have to do. So the first thing that I want to share with you, that in case we see the section 232 of the IBC, which says the members, officers, and employees of the board to be public servant. And we read this: the chairman, members, officers, and other employees of the board shall be deemed, when acting or purporting to act in pursuance of any provisions of this code, to be public servant within the meaning of section 21 of the Indian Penal Code. So this was the section that he always said that in case you want that kind of protection, then I can even say that you are a public servant. So where we could not decide amongst ourselves, so therefore we could not revert back to him. And then comes is the second section, which is 233. In section 233, in case we read that, no suit, prosecution, or other legal proceedings shall lie against the government or any officer of the government or the chairperson, member, officer, or other employee of the board, or an insolvency professional or liquidator, for anything which is done or intended to be done in good faith under this code or the rules or regulations made there under. So this is only a protection that we have as an insolvency professional whenever we are appointed as IRP, RP, liquidator, bankruptcy trustee. Then this is the only protection, that no suit, prosecution, or legal proceedings shall lie against us as an insolvency professionals or liquidator. Now, this is a section very next to section 232, where the code itself provides for public servant. Therefore, as per the code, insolvency professionals who are appointed as IRP, RP, or the liquidator are not public servant. When this judgment came, so it actually made us a public servant. Now, then we thought, let us understand what are the benefits of being a public servant and what are the obligations of being a public servant. Not that I would say that nothing, not that I could get many benefits, but the only thing that I could get, that the only protection to public servants is that no action can be taken against them without the approval of the employer. When I would say that without the approval of the employer, now in this case the employer is normally the central government or state government or any of the public sector undertakings. Now in our case, I think the permission of the regulator. In fact, we have two regulators. One is the Insolvency Professional Agency and the second is the Insolvency and Bankruptcy Board of India. So these two regulators, they need to give a permission to take any action, prosecution or suit against the insolvency professionals. However, this is not being done. So everything which is a kind of disadvantage of being a public servant, like applicability of the Prevention of Corruption Act, that has happened. But the other part, that has not happened. Even the Honorable Jharkhand High Court has also not given any observation on the permission or approval of the regulator. And this particular case, of course, we are not expecting anything and we are also not commenting anything on the RP and IRP. This is for the courts to see. However, as mentioned in the facts, so this is the kind of facts that has been mentioned. We are not commenting at all on any of the insolvency professionals. Whatever we are reading out of the judgment which is with us, and whatever facts are mentioned, we are only saying that. So in this case, allegedly, the promoter of the company, in fact, filed a complaint before CBI that the RP is asking 2 lakhs of rupees per month and also 20 lakhs of rupees in lump sum for extending various favors to him. And then the verification of the complaint was done by the CBI, and a trap team was formed and a raid was carried out at the company office, resulting in the petitioner RP being caught red-handed accepting illegal gratification from the complainant in the presence of the independent witnesses. Therefore, the criminal proceedings were instituted against the petitioner and an FIR was registered under Section 7 of the Prevention of Corruption Act. And this resolution professional, this insolvency professional, filed a criminal miscellaneous petition before the High Court of Jharkhand that this FIR should be quashed, as the Prevention of Corruption Act is only applicable to public servants. That was the basic argument. Then the court has finally held. Court has held that we have heard, and we actually, then the court also analyzed. In fact, this is a judgment which has come from Justice Chaudhary, and he says that the resolution professional shall fall within the meaning of public servant under Section 2, subsection C of the Prevention of Corruption Act. And for the reasons that the definition of the public servant as given in the Prevention of Corruption Act is wide and expansive, that it can be expanded. He further opined that it is not limited to those serving under the government or its other companies, instrumentalities, and drawing salary from public exchequer. That is not necessary. He also says that apart from the list of functionaries given in Section 2, subsection C, the definition also lays down the functional criteria to include within its fold those discharging public duty or any duty authorized by a court of justice in connection with the administration of the justice. Now, the Justice Chaudhary said that in case we read this Section 2, subsection C of the Prevention of Corruption Act, it is very clear that it is not necessary that the public servant should be drawing a salary from the exchequer or any of the instrumentalities of central government or state government. The Justice Chaudhary says that the public duty or any duty authorized by a court of justice is also within the meaning of public servant. And he, in fact, Justice Chaudhary relied on the Supreme Court judgment in the case of State versus CN Manjunath, wherein the question involved whether the licensed surveyors in taluks came within the meaning of public servant under the Prevention of Corruption Act. The apex court, Supreme Court, ruled in their favor, stating that they were public servants because they were discharging public duties. We will come to that part, whether whatever we are doing as an insolvency professional, are these public duties or not, that we will come. And further, Justice Chaudhary said that considering the facts that the appointment of a resolution professional is made during the resolution process before the Company Law Tribunal, with its approval, he will be public servant under Section 2, subsection C and Clause 5 of the Prevention of Corruption Act. That's what finally the Justice Chaudhary held. And in fact, there were many other observations. And one of the observations were, although the resolution professional does not figure among the officers as enumerated in Section 232, we just read that section. He referred this section in the judgment, Section 232. In case you want to see again, I can actually again come to that Section 232, where there is no mention of insolvency professionals. He, in fact, touched this issue, and he actually observed that it is not there in Section 232 of the IBC and within the meaning of section. However, he says that the Section 21 of the Indian Penal Code, the insolvency professional becomes a public servant. Those who are deemed to be a public servant enjoy certain immunities from the Criminal Procedure Code under the IPC for offences under Section 197 of the Criminal Procedure Code, the Criminal Penal Code, since the cognizance cannot be taken without the previous sanctions of the central or state government, as the case may be. He further observed that this does not refer to any immunity from the criminal prosecution for offences committed under the Prevention of Corruption Act. And he further observed that the Insolvency and Bankruptcy Code is a self-contained code, but only with respect to the matters provided therein. So therefore, he wanted to go beyond Insolvency and Bankruptcy Code, and it does not cover the matters like present. It is a very serious matter. It actually is a person caught red-handed while taking bribe. So therefore, it actually would be completely covered under the Prevention of Corruption Act. So it says that the Section 232 does not exclude operations of Penal Code. It's the operations of the Prevention of Corruption Act. Therefore, the plea that the petitioner is not a public servant and was immune from criminal prosecution under the Prevention of Corruption Act is not tenable. So the criminal miscellaneous petition was rejected by Justice Chaudhary. And finally, it was held that the resolution professional has a key role to play in the insolvency resolution process and to protect the assets of the corporate debtor. The nature of assignments of an insolvency professional that actually brings a duty on him, the performance of the functions which are in the nature of public duty. Therefore, it will come under the prevention of this thing. So this is what is the order, Ankit. So today, what we are going to see, so this was the order. Now, then we actually have to see now our research team. We are thankful to our research team that they did a good job. We now have to see what is the definition of public servant. Then our research team has found Section 52 of the Indian Penal Code, which also provides us the definition of good faith. Because see, the other thing that we have to discuss today is the protection of actions taken in good faith. And in this particular Section 233, we have the protection to insolvency professionals and liquidator. But the only condition is that the anything which is done or intended to be done in good faith under the code. So now we actually have to go back and see what is the definition of public servant, what is the definition of good faith. So we found the definition of good faith in section 52 of the Indian Penal Code. Then finally, it was held by way of various judgments that good definition of good faith, in fact, it starts with the negative. It starts with the negative. I will just show it to you. But then before that, then we saw that it actually went up to the due care and attention. Now, when we saw this definition, so then a very important word came out, that anything done without due care and attention cannot be considered as good faith. Because it starts with a negative definition. Anything done with the due care and attention, without due care and attention, cannot be held as done in good faith. So therefore, due care, then we started finding the definition of due care. And so it is like in various court judgments, then we found that the due care is further held as reasonable care, ordinary prudent man, ordinary prudent person, what he would do as the due care and attention. Then also we saw that the General Clauses Act 1997, it added, as far as the good faith is concerned, it added the word of honesty. So that also got added in the word good faith, that it should be due care, it should be with attention, it should be with honesty. A prudent man, whosoever is a prudent man, what kind of action that he would take under the facts, whatever facts are known to him. So these are the various things that we could find, that now, since the insolvency professional is a public servant, the definition of public servant that we have seen, we have also seen the protection to insolvency professional is only in case he act in good faith. And also when we saw the good faith, then the due care and the attention, then we also saw the honesty. So this is what we actually have to discuss today at length. And at this moment, Ankit, I would like to see in case there is any question or any of your observation.
So one question from Pavanji, he says that based on the verdict, what are the privileges as public servant that an RP can avail?
This is also a very big question that even we couldn't find many answers, but the only thing that I could find is that the privileges is that one, that normally no action should have been taken against any insolvency professional without the sanction of IBBI. That's what is the first outcome as a public servant is concerned. However, the High Court of Jharkhand has not mentioned anything in their order about it. It was an order passed on a very, very speedy manner. It has not mentioned whether the permission was taken from IBBI or not. Secondly, in my case also, the RERA, Real Estate Regulatory Authority, imposed a penalty on me in my person, on Anil Goyal, penalty of 1.49 crore of not attending to the RERA proceedings. So that was the orders passed by the RERA, and then without taking any permission from IBBI. And when I approached IBBI, so IBBI attended me very well, guided me very well, and I'm blessed today that the High Court of Jabalpur has stayed that order. I got full guidance from IBBI, and High Court of Jabalpur has stayed that order. However, the benefit of being a public servant, I feel that the RERA could not have imposed any penalty on me without taking the sanction of IBBI. And then IBBI should have said that any action has to be taken by us and not by RERA or not any other person. Now, even day before yesterday, a policeman came to our office that one of the female worker of those companies where we are liquidator, has filed a complaint to police that we went to the office of the IPE and we were misbehaved. And it was a kind of complaint which normally the woman files, and trying to write all those words which can catch the attention of media or the public. So policeman came and we showed policeman that this is the judgment of Anuj Jain from the Supreme Court of India. And in case there has to be anything, but to my understanding, any criminal action, I think the police is at liberty to take any action against any crime, even if it is committed by any public servant, if it is a crime. So I don't think the police would actually say that, yes, the police will not arrest you in case I have manhandled a person and I have done some kind of criminal offense, and police will not take any action till the time the police will go to IBBI. That's not something that I see practically. So we explained to that policeman, and he was the person who could understand our appointment as a liquidator, and also could understand that that particular female worker had the habit of complaining. So he, in fact, he was respectful to us, and that was the kind of benefit that we could get, that we are public servant. And the judgment of Supreme Court in the case of Anuj Jain also helped. So now the investigation report would be submitted that it is a false report, and the person is appointed by NCLT and he is doing his job, and he is distributing the amount to the workers as per section 53, and whenever there will be any amount available for them, it will be done. So that kind of report he would submit. I would say that there is a benefit of being a public servant. This judgment, of course, is not a very, very healthy judgment, because it is based on a corruption crime and the Prevention of Corruption Act. But yes, the only one part that we are interested is that in case of we are being adjudged as a public servant, that means that the IBBI should be the nodal agency for giving any kind of approval for any kind of prosecution or suit against the insolvency professionals. So, Ankit, any other thing as of now?
So Arunji is bringing in this term called, he says that when you talk about the definition of public servant, he has a comment on the judgment where he says that the Prevention of Corruption Act states that to be a public servant, one must be authorized in connection with administration of justice. So that is the definition, and he says that he's stating his opinion that when we read this part of the judgment, then it becomes difficult to understand that who has given us any authority to, there seems to be no authorization to an insolvency professional, which can be said to be authorized in connection with administration of justice. So that is his opinion.
No, I think I will definitely, I have the answer to this. Though I will actually give this answer through my slides, because this is a very important question and his observation is very correct.
So we will talk.
It is considered like what exactly the court has held, that the CIRP or a liquidation is an execution of judicial process. CIRP or a liquidation is an execution of judicial process. And once it is said that it is an execution of judicial process, this is what is the definition of public servant. Now, I will go to the definition of public servant. The question has been asked by him very rightly.
So then there are other questions which Sanjay ji is asking, that whether public servant only when handling assignment under CIRP or otherwise while advising in good faith. So he says that if you're giving some kind of a consultancy, can you still be a public servant? Maybe, maybe not.
No, exactly, because I'm saying that whenever we are executing a judicial process, like I'm on this particular slide and I'm highlighting this part. I'm only highlighting this part in case you can see, or to execute any judicial process. This is the definition that we have taken from section 21 of the Indian Penal Code. And this is a definition which is not only restricted for Prevention of Corruption Act, So the Jharkhand High Court has actually taken relied on the section 21 of the Indian Penal Code, and also the definition of public servant in section 2, subsection C of the Prevention of Corruption Act. So we have already seen that. Now we can see this section 21 of the Indian Penal Code, which actually says the public servant. The public servant denotes a person falling under any of the descriptions here under following, namely, number 1, every commissioned officer in military, naval, or air forces. Third, every judge, including any person empowered by law to discharge, whether by himself or by a member of any body of person or any adjudicatory functions. Fourth, any officer of a court of justice, including a liquidator, receiver, or commissioner. Now, there are many processes in our country where the commissioners are being appointed. It means the advocates are being appointed as receiver or commissioner. Now, whenever an advocate is appointed as receiver or commissioner, and whenever he is doing that particular assignment which has been given to him, where he is receiver or commissioner, then at that particular time he is a public servant. Otherwise, he is not a public servant. While doing his duties under that particular law where he is executing a judicial process, then only he is a public servant. Whenever he is out of that assignment, whenever he is not doing that assignment, he is sitting in his own office and giving a consultancy to somebody else as a chartered accountant, as an advocate, he is not a public servant. So let us read further. Whose duty it is as such officer to investigate or report on any matter of law or facts, or to make, authenticate, or keep any document, or to take charge or dispose of any property. So we have seen various assignments which are being given to advocates, receivers, where they are supposed to take over a property, sell it, take possession, or do any other action, or to execute any judicial process, or to administer any oath, or to interpret, or to preserve orders in a court, and every person specially authorized by the Court of Justice to perform any of such duties. Then that person will become public servant whenever he is doing that duty for which he is appointed as a liquidator, receiver, commissioner, resolution professional, insolvency professional, liquidator under IBC, liquidator under the Companies Act, receiver under the DRT Act, commissioner under the DRT Act, or any other act where the courts are appointed various people as for some kind of actions that they are supposed to do. So this was the definition under section 21 of the Indian Penal Code. Now going to the definition of public servant under the Prevention of Corruption Act, it says that any person in this service, because let us not read the entire, we are only saying the subclause 5 says any person authorized by a court of justice to perform any duty in connection with the administration of justice, including a liquidator, receiver, or commissioner appointed by such court. And then we move on to subclause 8. It says that any person who holds an office by virtue of which he is authorized or required to perform any public duty. So these are the two clauses under the Prevention of Corruption Act, which has been used by Jharkhand High Court, and which is otherwise also very correct, that whenever we are actually doing any duty as an insolvency professional, as a liquidator, what exactly we do? We only do a process. We do execution of a judicial process. CIRP is a judicial process. Liquidation is a judicial process. Selling some properties or taking over some properties in physical possession where some commissioners are appointed is a judicial process. So whenever a commissioner or a receiver is appointed by the court to take physical possession of the property, it is a judicial process. So whenever a person is doing a judicial process, it's a public servant. Yes, Ankit.
So basically, there are then other questions which extend this whole idea. So right now, I think we have a judgment which talks about RPs being a public servant for the purpose of Prevention of Corruption Act. Now, then the questions that are coming, Manoj is asking, will RTI also apply to IPs in case we say that because RTI Act is applicable on public servants? then of course there are other questions maybe which can take up later. So because what we understand here is that Prevention of Corruption Act imposes a duty towards public servants, and therefore there the inclusion of insolvency professional is a liability of a sort, because then you have to be covered under that act and you're reportable under the act in that capacity. At the same time, the question can be that in case two private parties are having a deal, having a transaction, which is a transaction which is a corruption transaction. Maybe a private entrepreneur is having such a transaction with another private representative of any company whatsoever. Will the Prevention of Corruption Act, then in that case, the Prevention of Corruption Act will behave very differently. But as soon as you say that, okay, this is because of court order and because you're appointed as an officer in duty, then yes, you get that power maybe from that order. This is what we are understanding. Now, with respect to the rights, you already shared that IBC talks about certain rights that insolvency professional under, I think you mentioned section 233.
Yes.
233 has some clauses to protect the insolvency professional. You also cited two examples where, you know, the other processes that are available or other hazards that are available to be misused or used against an insolvency professional are not applicable then. So are not available unless the IBC is involved or IBBI is involved rather. So that's perfectly good. I think, but then yes, saying that once we are a public servant as per the Prevention of Corruption Act, we will also be a public servant for all other acts might be an extension. This is what my feeling is, but I think we can have your opinion on this.
So I think whenever we are doing a judicial process, in fact, that is the reason that I'm now coming to section 17, 18, 20, 25 of the IBC, just to showcase to my professional colleagues that we have to be very, very careful, because we are actually executing a judicial process. In case we see our responsibilities and our powers, which actually comes from section 17, where the entire management of the company is vested within IRP or RP. That's something which is a very, very big power that has come to us from a court, and the court is actually doing a execution of a judicial process. So the debtors' possession and the creditors in possession, powers of the board immediately stand suspended and it comes to the RP. So this is something which is basically what we're trying to say. The objective of all this is to execute a judicial process. Now, let us see the section 18, like the talks about the duties and the functions of the RP. Section 20, the has the powers to appoint agencies to carry out his management function. Then we also have the going concern we have to maintain and they keep a control. Basically the RP becomes in a steering position. So all of a sudden, a company, maybe the company is having a net worth of say 10,000 crore. All of a sudden, based on one order, the IRP or RP becomes so powerful that all of a sudden he becomes the CEO of the company. And he can run the business, he can keep it as a going concern, he has to appoint agencies. And whenever we go to ROC's website, MCA website, now they've started calling us CEO of the company, because see, our signatures are now required as a CEO of the company whenever we are appointed as IRP or the RP of a company. Now, these are all the kind of various acts under section 17, 18, 20, and 25, which are basically a judicial process. And we are only doing the execution of judicial process. And coming back to the definition of section 2, subsection C of the Prevention of Corruption Act and section 21 of the Indian Penal Code, definitely we are executing a judicial process. So therefore, we can enter into a contract on behalf of the corporate debtor. We can amend a contract, we can terminate a contract, we can raise interim finance, we can give instructions to all their employees, and we can appoint accountants, legal professionals. Every power comes to us. We can even raise interim finance. Every power comes to us in this CIRP or in liquidation, and that comes from a code and that comes from an order. Therefore, we become a person appointed by a court for the purpose of execution of a judicial process. Therefore, I think there is a complete natural flow of the definition, the process, the judicial pronouncements, and I definitely support this judgment that insolvency professional, whenever he is doing a job of execution of a judicial process, is a public servant. Now, whenever we conduct the insolvency processes, as I said already, that these are all this process, whatever we are doing, we are actually doing in our capacity where we actually have the control on all the assets of the company. In fact, we are doing our process where the company is actually having something like 200 crores of working capital, 500 crores of working capital, and we are actually we are purchasing, we are placing order of purchases, we are selling the orders. So we are doing it as a public servant, and we are fully regulated. In case we are not a public servant, then of course the greed of any human may overtake. So therefore, there has to be a deterrent, and that deterrent is that we are public servant and we are executing a judicial process. Therefore, the resolution plans, even whatever we do for getting a resolution plan, how many people that we have to invite, how many resolution plans that we have to see. So all this is basically the process that we are executing. Now let us see the immunity. We have already checked section 233, where the immunity has been granted to an insolvency professional only in case where anything is done or intended to be done in good faith under this code. Now we actually come to that judgment, which is the judgment of Honorable Supreme Court dated 2nd of March 2021. 2nd of March 2021 in the matter of JP Kensington Boulevard Apartments Welfare Association versus NBCC India Limited. This is basically the main petition name, and whereas the petition which was filed by Mr. Anuj Jain when he was arrested by the Uttar Pradesh police, then the same name actually continued, but it was a totally different scenario when Mr. Anuj Jain, an insolvency professional, was arrested by the police, and he was arrested by the police station Beta 2 district, Greater Noida, Uttar Pradesh, and he was produced before the court of Chief Judicial Magistrate, Gautam Budh Nagar, Uttar Pradesh. And in this particular case, the Honorable Supreme Court protected him almost overnight, and we all insolvency professionals must be very, very thankful to the Honorable Supreme Court for such a speedier action. And it was held by the Honorable Supreme Court that we are appalled to see. That means we are disgusted, or we are sad, or we are concerned to see that the manner in which the Uttar Pradesh has handled this matter emanating from FIR number so-and-so registered at police station, including to take extreme step to arrest the interim resolution professional, Mr. Anuj Jain, who was working in that capacity pursuant to the order passed by the court and entrusted with the functioning of the company in question. It is seen that the police official dealing with the case is not familiar with the privileges of IRP by the court in terms of section 233 of the Insolvency and Bankruptcy Code. In the meantime, we direct immediate release of the applicant, Mr. Anuj Jain, who is presently in the custody of police station and has been produced before we further direct the investigating officer not to take any coercive action against the appellant in connection with the subject FIR until further orders. Now, this particular immunity, and there is a general clause which is 238, which is an overriding clause, which says that the presence of IBC has an overriding effect of all other laws. So therefore, when we see the section 233 and then we see section 233, so then we finally see actually what is there in the section 233. So in section 233, it is written, which is done or intended to be done in good faith. So in case we have done something in good faith, then section 233 will protect us. Now, what is good faith? How the good faith can be proved? That is a matter of discussion that we will now start. Although the time would be limited, but this is something which is now very important for the protection of insolvency professionals, which is there in section 233, that what is insolvency professional is only protected in case whatever he is done has been done or intended to be done in good faith. This is what we are now discussing. Now, let us try to see what is the definition of good faith in section 52 of Indian Penal Code. Indian Penal Code says it starts with nothing. It starts with negative. Nothing is said to be done or believed in good faith. Nothing is said to be done or believed in good faith, which is done or believed to be done without due care and attention. So in case due care is not seen, attention is not seen, it would not be considered as a good faith. If a person is sleeping, that is not good faith. If a person is not taking good care, that is not a good due care. So therefore, negligence, not doing anything on time, and doing anything without any attention, missing anything because you are not attentive, you have not taken care of any particular timeline, that means it is not a good faith. That means you have not done that part as a good faith, under good faith. Now coming down to the various kind of judicial pronouncements which actually has been given to me by my research team, I would like to give a great thanks to Advocate Amar Vivek and Advocate Sanjay Agarwal, who actually have helped me do this research, as we being chartered accountant, me and Ankit is also a law graduate, but I am not even a law graduate. But then I am actually supported by a legal team of a law firm, and they in fact support me in all these matters. So I'm really thankful to them, because this is not restricted to IBC. Whenever there is IBC, I can do the research myself. Whenever it is outside the IBC or SURFACE, then I need some help. So this is where the expression good faith in criminal jurisprudence has a definite connotation. So now all these lines has actually been taken out from some of the judicial pronouncements. Its import is totally different from saying that a person concerned has honestly believed the truth of what is said. Because this section 52 of the Indian Penal Code starts with a negative tone, excluding all except what is allowed to be within its amplitude. So what is allowed to be within the amplitude of good faith, that has to be done with due care and attention. So this is the definition. So when we say the due care denotes a degree of reasonableness. So when we saw the dictionary, then we found that the due care means reasonable care. Then we also saw that reasonable care means any ordinary prudent person would exercise. That is what is called reasonable care. It is not expected that a person should be a super intelligent. It is not expected that the person should be a person of super connection so that he will have all the facts of the case. So a ordinary prudent person, whosoever would do something under that circumstances, knowing those facts, would be considered to be in good faith. Honesty. The element of honesty was also introduced by the definitions prescribed by the General Clauses Act. That is not, the honesty has not been added into section 52 of the Penal Code, but it has actually been added by the General Clauses Act 1977. That is where it was added. So nothing is an offense which is done by any person who is justified by the law or by a reason of a mistake of the fact, and not by reason of a mistake of law, in good faith. So in the general clauses, section 3 subsection 4 says, good faith, a thing shall be deemed to be in good faith where it is in fact done with honesty, whether it is done negligently or not. So this is slightly different. When we see the definition of good faith under section 52 of Penal Code, it says that it has to be done with due care and attention. When we say that the definition of general clauses, it says that it should be done honestly, whether it is done negligently or not. So there is a conflicting definitions. So Ankit, what do you say on these conflicting definitions under section 52 of the Indian Penal Code and under section 3, subsection 14 of the General Clauses Act 1977?
I think this is something that is part of the IPC. So there must be judicial pronouncements which have harmonized or read these in combination and kind of made an interpretation out of these things. Because when it comes to criminal law, there is a lot of jurisprudence and discussions on all these laws, which is important to be read with the act itself.
You're absolutely right, Ankit. So this is what our legal team, our team has done. See, when they have seen the conflicting definitions, then they went and they saw various judicial pronouncements. So one thing that they have shown to me, that this is onus of proof in cases where it is claimed that good faith has been exercised. That burden is on the accused to prove that it was done in good faith. Again, whether it is the personal knowledge of that person or not, that is also considered to be a defense. And it was also used for the defense that it was not in my personal knowledge. Now, the word due care and attention implies that the accused must have made an inquiry in a reasonable manner. That is also a kind of due care and attention that has also been defined. Again, like with all circumspection, it is true that the accused is not bound to prove that the reasons relied upon were foolproof or without the possible of any error or chance of mistake. So however, the accused must show that he got the information, reasons relied upon were from proper source, and he had reasonable grounds to act based on the same. And the accused must prove by preponderance of the probability that there was a good faith on his part. So these were various judgments, and the various places the good faith has been taken as defense. Now, what happens, Ankit? In section 76, section 77, and section 78 and section 79 of the Indian Penal Code, there are some defenses which has been given. And these are the defenses of good faith. So these are, again, section 76 of the Indian Penal Code says that the good faith by the person who believes himself to be bound by law or do it and to do it in and not an offense. So he was believing that it is a law and doing this is not an offense. That is also section 76 of the Indian Penal Code says it's a defense. Section 77 also says that if it's like if any judge acts in the exercise of his judicial power given by law in which he believes it to be done in good faith. This is only for the protection of the judges. Then section 78 says if an act is in accordance with the law or any order of the court. Now this section 78 is saying very important thing. Now it says, section 78 says, Ankit, that in case a person acts according to an order of a court, and later on he finds, even at the time of taking that action, he found that this particular court order is incorrect. It is not as per law, but yes, if he has taken an action as per the court order, he will be protected and he would be considered as a person who has done the job in a good faith. So even if he knows that this particular judgment is wrong, that's a very unique scenario. So that means that the courts, based on the court order, if somebody does something, that will be considered as a good faith. Again, section 79 of the Indian Penal Code says that an act done in good faith by a person by reasons of a mistake of fact, and therefore he believes that he is justified by the law in doing so, is not an offense. So various case laws, Ankit, and all these case laws are basically having discussions on the good faith and say some old judgments, some new judgments, and also the due diligence and care. When we are studying this due diligence and care, again and again it is coming as the prudent person, reasonable and prudent person. Again, it is saying again and again due care and attention. But it is the duty of the accused to prove that it was done in good faith. Again, I said section 79, again, there are various judgments on section 79 of IPC, which is again a defense. So again, various judgments on section 79, section 77, as we said that these are sections 76, 77, section. So these are various kind of discussions that we can go ahead and ask our lawyers whenever there is anything which happens, and when there is a dispute regarding good faith, that actually happens, and there are a lot of judgments on this, and therefore what we are trying to say is the Prevention of Corruption Act is applicable to insolvency professionals. So this was another judgment, CBI, Bank Securities and Fraud Cell versus Ramesh Gilly. So it was also defined very correctly who is public servant and what is the public duty, and therefore all this becomes a public servant is an obligation. Public servant is not a kind of advantage. Being a public servant is an obligation. Always it has to be a person who actually is doing something with the due care, with the honesty, and with attention. That's what I wanted to say, Ankit. In case there are questions, we can take up some questions. But as far as what we are saying is exactly because various judgments are seen, and I'm not sure whether the judgments actually everyone would have any benefit of these judgments. And whenever something comes, the lawyers will take up the appropriate judgment for anyone's case. But I think it is a time that we can see in case there are questions or anyone who would like to discuss something about the implication of this judgment. And what I'm trying to now conclude is that, for example, if an RP has tried to take books of accounts from the suspended management, he could not get the books of account. And then he files an application under section 19, subsection 2 for non-cooperation. And still he is not able to get the books of account. Then he tries to get the bank statements of various bank accounts, and he is not sure whether all the bank accounts have actually come to him or not. Then he tries to restructure the books of account, and then he in all this process, he is not able to file his income tax return. He is not able to file his registrar of companies returns, or he is not able to comply with various other reasons. To my understanding, all these acts, whatever he's done, that is a good faith. That has been done with due care. That has been done with attention. But the results are not coming. Now, in case there is any loss which is caused to corporate debtor by way of any penalty, by way of any kind of late filing fee, I think the insolvency professional would be protected. Even if there is a circular that if it is done because of the negligence of the RP, then it will not become CIRP. But in case the RP is able to prove that it is not his negligence, he has done with the care, he was attentive, he was not sleeping, then he would be protected. This is what I wanted to conclude. Ankit, you can add and you can see if there is anything, any observation from any other person that also can be seen.
So I think basically RTI, we are kind of coming to the conclusion that RTI should not apply to IPs because of the confidentiality clauses which are part of the whole CIRP process. So it would not make sense for any RTI kind of a provision. Rather, I would like to say here that many disclosures that an RP makes are anyways public disclosures, which are readily available to the entire society. So whether it is the data that you upload in the form of CRP 1, 2, 3, 4, or whatever, and then you talk about various other disclosures on the website of the IP or the company or the CD. So these disclosures are what are mandated under the law. You can't make further disclosures. Other things, there are confidentiality clauses applicable on valuation reports and other processes. So there we can't go public with all that information. I think that's important. Uh, the advantage of taking this judgment or advantage of this judgment, I don't see too many advantages to an IP with respect to this judgment per se. But yes, there is an advantage to IPs when it comes to the judgment of Anuj Jain ji, which was shared by Anil sir. It is also then important to see how IBBI has protected insolvency professionals in their line of duty. So that is something that is certainly important, and that's there. Then, of course, one of the challenges are from Arun Bansalji. Arun Bansalji says that if the RP is stepping into the shoes of the erstwhile directors of an ailing CD, how can the RP discharging the duties of erstwhile directors for a limited period, how can become a public servant when the original directors were not a public servant? So my answer to that is, Arunji, that we are doing more than stepping into the shoes of the erstwhile directors. We are running a court-appointed process or an IBC process. So it is not only that we are doing that directors, and what is important here to understand is that we are a court appointed authority in most sense, so that
I would
makes
like
the
to add,
differentiation.
Ankit, with regard to this question. So when we talk about a suspended management, let us see how the suspended management is appointed. One, that the suspended management is appointed by the shareholders. That means anyone who is the owner of the company can appoint the management. That maybe they may appoint themselves, who are shareholders, or they may appoint somebody else. That's what is the company law. So they are appointed under the company's law, so their duties, their obligations are as per the Companies Act. So as far as an insolvency professional is concerned, he is not an investor, he is not a shareholder, he is not a management expert of that particular segment of industry. So he is appointed only to execute a judicial process. So whenever he is appointed by a court to execute a judicial process, which is CIRP or a liquidation, this is what is held by the court, that he will become a public servant while he is executing a judicial process.
So Ashwini Mehraji has a question. He says that in case NCLT and IBBI have already established good faith and lack of malified on part of the RP, and a criminal case is filed by a former director against the RP on the same charges, is it in order for the police department to re-examine the issue all over again?
No, Ankit, I couldn't understand. Sorry, can you repeat that?
In case NCLT and IBBI have already established good faith and lack of any malified on part of the RP, and a criminal case is filed by a former director against the RP on the same charges, then can the police department re-examine this issue all over again? That's Ashwini's.
I still feel that investigation by a police department is not a suit. It is not a prosecution. Investigation is basically a process of getting information and trying to understand the crime, whether the crime has taken place or not. Similarly, when an income tax department is asking for some information by way of a notice that there is an assessment pending and you have filed a return of income and we need to get this, please provide this information, that is also not a suit, that is also not a prosecution, that is also not a proceeding against the company. Getting information, seeking information, I think it becomes an important duty of the RP to provide that information to income tax department, to even the ED, to CBI, to police, to SFIO, or even to any of the creditor who asks for any information which he can reasonably provide. Providing information is not a suit, it's not a proceeding, it's not a prosecution.
So I think there's another question. There is another comment from Ankit Garg. He says that, with due respect, to my mind, that would not fall within good faith. I have read IPC thoroughly. An analogy of good faith can be drawn from general exceptions illustrations under section 76 to 95 IPC. It says that wherever you did an act without the bad intention, an offense has been committed during that act, then that would have to be proved by you that it falls within the exception of IPC.
I think
Section.
we also, I think he's also saying the same thing, and we are also saying the same thing, that we don't think that there is any protection. Good faith has to be proved.
Yes, good
Good
faith has
faith
to
has
be
to be
proved,
proved.
and after good faith is proved, then the burden of proof
Then
shifts.
only the 233 is applicable.
Yes, I think we're all on the same page.
We are all on the same page.
So great. I think that's the questions. I think we were able to take up all the questions, and
so I think again overwhelmed with the kind of presence, with the kind of audience that we have today. We are overwhelmed. We are really thankful to all of you. Please keep motivating us. Please come. Please circulate whenever we send any kind of alert to you for our upcoming subject. Please do circulate in your groups. We just want that whatever we are doing, the benefit of this particular hard work should actually be accessible to more and more people. Therefore, we actually thank you that spreading education, spreading knowledge, spreading experiences is the only objective that we have. We have no other objective. And we are thankful to you that you, every time you come in big numbers, we get motivated. Thank you very much, all the participants. Thank you, Ankit. And thank you, the law firm who is actually helping us in getting all these legal issues, wherever the IBC or SERFACI. IBC and SERFACI, we both can do, but for other things, we actually had taken a help. Last Saturday also, we had taken a help of a law firm regarding the SEBI compliances and the stock exchange compliances. And please do give us the feedback, what kind of subject that you would like to take up. Thank you very much.
Thank you, everyone. Thank you.